These appeals concern the criminal offence in Section 12(1)(a) of the Terrorism Act of 2000. Under that provision, a person commits an offence if they express an opinion or belief that is supportive of a proscribed organisation, and in doing so are reckless as to whether a person to whom the expression is directed will be encouraged to support a proscribed organisation. Proscribed organisations are organisations which have been determined by the government and Parliament to be involved in terrorism. The Supreme Court is asked to decide whether the terms of this offence interfere disproportionately with the appellant's right to freedom of expression protected by Article 10 of the European Convention on Human Rights. The appellants have both been charged with offences under Section 12(1)(a). They are alleged to have expressed an opinion or belief that is supportive of Hamas, which is a proscribed organisation, and to have been reckless as to whether persons to whom their expression was directed would be encouraged to support Hamas. Neither of the appellants' cases has yet gone to trial. Preparatory hearings were held in both cases to clarify the applicable law. In the first appellant's case, the judge held that if the ingredients of the offence were proved, there was no need for the jury to conduct a separate assessment of whether a conviction would interfere disproportionately with her convention right to freedom of expression. In the second appellant's case, the judge rejected the contention that the offence was too uncertain to be prescribed by law as required by the Convention. The judge also held that establishing the ingredients of the offence was sufficient to ensure that a conviction was compatible with the second appellant's convention right to freedom of expression. The Court of Appeal dismissed the appellant's appeals, but certified the following point of law of general importance as being involved in each case. The point is, do the terms of Section 12(1)(a) represent a disproportionate interference with the appellant's rights under Article 10 of the Convention? If so, is it possible to read down the terms of the offence to make them compatible? The Supreme Court is concerned only with those issues of law. It is not deciding whether the appellants are guilty of any offence. That will be a matter for the jury at their trials if the evidence establishes a case which is fit to go to the jury. The Supreme Court unanimously dismisses the appeals. It holds that the Section 12(1)(a) offence does not interfere disproportionately with defendants' rights to freedom of expression under Article 10 of the Convention. It follows that there is no need for trial courts to carry out separate proportionality assessments to ensure that each defendant's conviction is compatible with Article 10. The Court emphasises that in order to be guilty of the offence, the defendant must, in the first place, express an opinion or belief that is supportive of a prescribed organisation. Expressing an opinion or belief which coincides with the organisation's aims or beliefs is not sufficient. For example, a person can express support for Palestinian statehood or for ending Israeli occupation of Palestine without expressing support for Hamas. The defendant must also have known that the opinion or belief is supportive of the prescribed organisation. So if, as the first appellant maintains, she was unaware that her remarks might be understood as being supportive of Hamas, she could not be guilty of the offence. Secondly, the defendant must also, in expressing an opinion or belief that is supportive of a prescribed organisation, be reckless as to whether a person to whom the expression is directed will be encouraged to support a prescribed organisation. In order to be reckless, the defendant must be aware of a risk that a person to whom the expression is directed will be encouraged to support a prescribed organisation. In addition, it must, in the circumstances known to the defendant, have been unreasonable for the defendant to take that risk. So understood, the offence is compatible with Article 10 of the Convention. Article 10 is a qualified right which means that restrictions on freedom of expression will be justified if they are prescribed by law, pursue a legitimate aim, and are necessary in a democratic society. The Supreme Court holds that the Section 12(1)A offence can be justified according to this test. First, the terms of the section are sufficiently clear to be prescribed by law. They enable individuals to regulate their conduct, if necessary, after taking legal advice. Section 12(1)A is no more difficult to interpret than other counterterrorism legislation, which has been held by the European Court of Human Rights to meet this standard. Secondly, the offence is designed to combat radicalization, that is, the use of speech or writing to encourage others to support terrorist organizations. Experts considered this to be the most serious problem facing counterterrorism at the time when Section 12(1)A was introduced. The evidence presented to Parliament during the passage of the legislation demonstrates that there is a real risk of terrorist attacks in the United Kingdom and elsewhere, which are carried out by individuals who have been encouraged by the words of others, for example, through radicalization online. It follows that Section 12(1)A pursues a number of the legitimate aims mentioned in Article 10 of the Convention: the protection of national security and public safety, the prevention of disorder or crime, and the protection of the rights of others, both within the UK and in other countries. These have been recognized by the European Court as legitimate aims of counterterrorism legislation. Thirdly, having considered the relevant case law of the European Court, the Supreme Court concludes that the restrictions imposed by Section 12(1)A are justified. To begin with, the offence was introduced by Parliament to respond to a particular threat posed by radicalisation. As I've said, the evidence establishes that there was a pressing need for the offence. The next point is that the offence only restricts expressions of support for organisations such as Hamas that have been proscribed in accordance with the procedure set out in the Terrorism Act, after the government has decided and Parliament has accepted that the organisation is involved in terrorism. In addition, the section does not prohibit the expression of views or opinions which are supportive of the aims of a prescribed organisation. It only prohibits the reckless encouragement of support from others for organisations involved in terrorism. The Supreme Court's conclusion that the ingredients of the offence ensure that a conviction does not interfere disproportionately with the defendant's rights under Article 10 is subject to two important qualifications. First, the jury must be sure that each of the ingredients of the offence have been proved to the criminal standard before they are entitled to convict the defendant. If it would not be possible for a reasonable jury to reach that conclusion on the basis of the evidence before them, the trial judge will have a duty to uphold a submission of no case to answer. Secondly, the trial judge is required by the Convention and by domestic law to ensure that any sentence imposed in the event of conviction is also proportionate. For these reasons, the appeals are dismissed. The Court will adjourn.